essay review for Torts and the expansion of Emerson Bar Review. So that's the playlist this is going to be in. It may not interest many people because it's on medical malpractice. It's a hypothetical and an actual essay question from the California First Year Students Law Exam. What I'm going to do is show you the link to that and also the playlist. Now, I've reviewed the question before coming on, and I will tell you that Emerson does cover a lot of topics in his bar review essay, but vicarious liability he touches on here and there, and he doesn't really talk too much, to my knowledge, about medical malpractice. Now, I haven't watched every single video through, but I thought we would go over this one and the selected answers. Now, this is essay practice, so what I'm going to do is I'm going to read it off, and then you can pause the video, and then I'll go over the two model answers. And remember, when you're writing, to do issue, rule, analysis, conclusion, and answer the call of the question. So let's go first and read this. This is taken from the California Bar, October 2021. It's the latest one I can find on the babybar, which has a smaller selection of subjects. Okay, so let's look at question number 4, which is this is a torts question, and excuse me, I'm losing my voice. Maybe I ought not to do this. So basically, 6 months ago, Paul had abdominal surgery at Aspen Hospital to remove an ulcerated section of his large intestines. Dr. Johnson performed the surgery. Dr. Johnson told Paul that there were no problems with the surgery and assured him he would not have any issues with his abdomen in the future. Dr. Johnson knew that one of the surgical clamps had been left inside Paul's abdomen and would likely cause future problems. Okay, now, 3 weeks ago, Paul experienced severe abdominal pains and went to the emergency room of Valley View Hospital. So this is another hospital. The emergency room doctor, Dr. Norman, immediately performed emergency abdominal surgery and removed an old surgical clamp. The old surgical clamp caused a massive infection in Paul's abdomen. 1 week after the surgery done by Dr. Norman, when Paul was recovering in post-surgical wing of Valley View Hospital, it was discovered that his lungs had been permanently damaged by a post-surgery pulmonary embolism, that is, a blood clot that forms in the body after surgery and then travels through the bloodstream to the lungs. Dr. Norman told Paul that a review of the medical charts indicated that the Valley View Hospital's nurses should have discovered the embolism 2 days earlier than they did, and if they had, his lungs would not have been damaged. Now, when Paul asked Aspen Hospital about his first abdominal surgery, Aspen Hospital denied that it was responsible for any of his injuries. What claims may Paul reasonably assert against, and for what injuries could he recover from? 1. Aspen Hospital, discuss. 2. Dr. Johnson, discuss. 3. Valley View, discuss. Now pause it here, and I suggest that you answer in the order that it's questioned, not in the order that you feel like answering it. Always follow the call of the question. Okay, now I'm just going to go on to the model answers. We're going to look at answer A first. Paul versus Aspen Hospital. Vicarious liability. When liability is imputed from the tortious acts of a third party onto a defendant because of a special relationship between the defendant and the tortfeasor. Respondeat superior. Generally, employers are held vicariously liable for the torturous acts of their employees, who are acting within the scope of their employment. Here, Dr. Johnson was a surgeon working at Aspen Hospital. Dr. Johnson performed the surgery. Thus, Dr. Johnson was acting within the scope of his employment. Independent contractors. One who is engaged to perform a service for another, free from control and direction from his employer client with regard to the methods and manner of performance except as to results. Generally, employers are not vicariously liable for the torturous conduct of independent contractors unless the activity is inherently dangerous or because of public policy considerations, the duties are non-delegable. Here, Dr. Johnson was engaged to perform surgery, a service which was free from control and direction from Aspen Hospital with regard to all aspects of his performance except as to the results. Thus, Dr. Johnson is an independent contractor of Aspen Hospital. Inherently dangerous. Here, the activity of surgery is inherently dangerous, as a surgeon is using tools to cut open and manipulate vital body parts within the torso of Paul. Thus, the activity is inherently dangerous. Notice how they underlined and bold these. This makes it easier on the reader to quickly go through it because a lot of these readers don't have a lot of time to read it in slowly and carefully. Non-delegable. In addition, as consent was strictly given to Dr. Johnson before surgery, which is too personal, and delegation of the duties would materially change the obligee, Paul's expectations, the duties are non-delegable. Therefore, Aspen Hospital will be vicariously liable for the torturous conduct of Dr. Johnson. Aspen Hospital will be liable for the same damages that Dr. Johnson is found liable for. Paul versus Dr. Johnson. Negligence. A duty to conform to a standard of conduct that is breached by the defendant, and the breach is the actual and proximate cause of the plaintiff's damages. Now, there's a whole section in Emerson's on negligence, if you want to go over that, and duty of due care. And also I did an expansion of that with some of the theories, if you want to review that as well, in the EBRs. So, duty is owed to all foreseeable plaintiffs. Here, Paul is a patient of Dr. Johnson, whom Dr. Johnson is performing surgery on. Thus, Paul is a foreseeable plaintiff who's owed a duty of care. Now, I want to tell you something. This person could have broken this apart better and made it easier for them to read. They did a pretty good job, and it is a passing answer. It may be a 75 or 80, but it could be a 90 if they broke it apart more. And what do I mean by that? They could put the rule, the issues, and just broke it apart. With the duty, notice they didn't put Cardoza and Andrews here. They just put the general consensus. So thus, Paul is a foreseeable plaintiff who's owed a duty of due care. Okay, so that's, they could have done better. Standard of care. Generally, one must act as a reasonable, prudent person. Additionally, one will be held to a higher standard of care when they are a professional. Professionals are required to possess the knowledge and skill of a member of the same profession in the same or similar localities in good standing. Here, Dr. Johnson will be held to the standard of another professional of the same profession, surgeon. Breach. A breach occurs when the defendant's conduct falls below the requisite standard of care. Either the defendant did something that a reasonable person would not have done, or the defendant did not do something that a reasonable person would have done. Here the facts only indicate that one of the surgical clamps had been left inside Paul's abdomen. Thus, there may be insufficient facts to determine that Dr. Johnson himself breached his duty of care. I disagree with this, so I'm putting in my comment here. If you look at the beginning of the fact pattern, Dr. Johnson admitted he knew that it would cause problems, and he knew he left it in. He did not feel like opening it up, and he lied to the patient in the first paragraph. The link to the whole thing is below. I'm only going to read the first response. There's a second response you can look at, but I'm telling you these are not perfect. Okay, re ipsa loquitur. When the accident is the type that would not normally occur unless someone was negligent. Now, was this an accident? The instrumentality causing the accident was the defendant's sole control. So did they read the fact pattern closely? It says here Dr. Johnson is the lead surgeon. Nowhere in there did it say Dr. Johnson was the lead surgeon. Okay, so this person, but he put it was in his sole control. He highlighted some important points, or she, because he's responsible for opening Paul's body, performing surgery, and closing Paul back up. This is the type of accident that would not normally occur unless someone was negligent. Finally, Paul did nothing to contribute to his injury, as he was presumably unconscious during surgery. Thus, breach will be inferred. Okay, so I mean, you can scroll back up and look at the fact pattern. I do not have time to go through this whole thing and go back and forth. I'm just going to read it off, give you the link. You can listen to what I say and then go double check, because I'm telling you, there's mistakes in here, but this was a passing answer. And I do believe it's one of the higher grades. Causation. For the plaintiff to recover, the defendant's breach must be the actual and proximate cause of the plaintiff's damages. Actual cause. The defendant's breach must be the actual cause of the plaintiff's injuries if the plaintiff would not have been injured as, when, and how he was but for the defendant's breach. Here, Paul would not have had the clamp in his abdomen but for Dr. Johnson's breach. Proximate cause. The defendant will be the direct proximate cause if there were no intervening acts by third party or act of God between the defendant's breach and the plaintiff's injury. All direct causes are proximate causes, and the defendant will be liable if harm was foreseeable. Here there were no intervening acts between Dr. Johnson's surgery and the clamp being stuck in Paul's abdomen. Thus, Dr. Johnson's breach is the direct proximate cause of Paul's injury, as harm is reasonably foreseeable. Additionally, Dr. Johnson will be the indirect proximate cause of Paul's injuries where there is an intervening event and an intervening event is foreseeable. Here, medical malpractice is a foreseeable intervening event. What? Thus, Dr. Johnson will be liable for the medical malpractice claim established against Valley View Hospital. Doctors carry medical malpractice insurance. Okay, so basically this, I mean, if you're going through this really fast, it looks really good. Okay, and that's usually what they do. But I'm telling you right now that, if you look at the fact pattern that we just read off and you remember what's in there, you're going to see that there's details that might have been skipped over and might be just kind of fudged a little bit. And this is very, it looks good on paper. So, damages. Economic injury is not recoverable in a claim for negligence. There must be some actual physical injury to a person or property, yes. The personal injuries the plaintiff can recover. Special damages, which are medical costs, reasonable and related, economic loss, including lost wages, diminished future earnings capacity, and permanent disability, estimated by life expectancy and statistical averages. The plaintiff must also recover general damages for pain and suffering, which are essential to a claim of personal injury. Here, Paul suffered actual physical injury to his person, thus Paul is entitled to recover the special and general damages caused by Dr. Johnson's negligence. Avoidable consequences. The plaintiff has a duty to mitigate the damages by taking reasonable steps to avoid further injury after the initial injury is sustained. The defendant will not be liable for the damages that could have been avoided. Here, Paul went to the emergency room and had emergency abdominal surgery to remove the surgical clamp. Thus, Paul took reasonable steps to avoid further injury. Thus, it's unlikely that damages will be reduced for failure to mitigate damages. Fraud, misrepresentation of a material fact by defendant with scienter, which induces the actual reliance by the plaintiff, resulting in damages to the plaintiff. Non-disclosure. Generally, if there's no liability for non-disclosure and no duty to disclose information unless a fiduciary duty exists. Here, Dr. Johnson is Paul's doctor. Thus, a fiduciary duty exists in which Dr. Johnson has a duty to disclose the material fact that a clamp had been left in his abdomen. This is a material fact, as Dr. Johnson knew that it would likely cause future problems. There you go, I didn't even have to scroll back. Okay, thus, Dr. Johnson made a misrepresentation of a material fact. That's putting it mildly. Scienter, with the knowledge that the statement was false or a reckless disregard as to truth or falsity. Here the facts state that Dr. Johnson knew that one of the surgical clamps had been left inside and that it would likely cause future problems. Thus, his statement was made with scienter and thus fraudulent. Battery. An act by a defendant that intentionally causes a harmful and offensive contact to a plaintiff's person. Here, Dr. Johnson knew that one of the surgical clamps had been left inside Paul's abdomen would likely cause future problems. Additionally, in spite of his knowledge of substantial certainty, Dr. Johnson told Paul that there were no problems with the surgery and assured him he would not have any issues with his abdomen in the future. This, however, was a lie, which constitutes the volitional act by Dr. Johnson. Harmful contact did eventually indirectly happen to Paul. Paul experienced severe abdominal pains. Thus, it was an indirect harmful contact to the physical body of Paul, plaintiff's person. Punitive damages. Punitive damages are allowed where the defendant's conduct was willful, wanton, or malicious. Here, the fact that Dr. Johnson made a fraudulent statement with scienter may suffice for malicious conduct. Thus, Paul may likely recover punitive damages. Therefore, Paul can reasonably assert a claim for battery, negligence, and fraud against Dr. Johnson's. Paul versus Valley View Hospital. Negligence defines supra. Duty defines supra. Standard of care defines supra. And then breach defines supra. And here Dr. Norman told Paul that a review of the medical charts indicated the Valley View Hospital's nurses should have discovered embolism 2 days earlier than they did. And if they had, his lungs would not have been damaged. Valley View Hospital's nurses did not discover it when they should have. Thus, they breached their standard of care. Causations define supra. Actual cause defines supra. Here, Dr. Norman reviewed the medical charts. He concluded if they had not breached their duty, his lungs would not have been damaged. Thus, Valley View Hospital's nurses' breach is actual cause of Paul's lung damage, proximate cause. Here there were no intervening acts between the nurse's inspection and Paul's infection. Thus, an infection is not an embolism. Oh well. Thus, their breach is the direct proximate cause of Paul's damages. Damages. Here, Valley View Hospital will be vicariously liable for the special and general damages defined supra that were caused by the nurse's breach of duty with regard to the lung infection. I hope you enjoyed that. The links are going to be below if you want to go through the playlist or these areas. If you want me to expand on any topics that you cannot find in Emerson, or I'm expanding. I'm going through it one by one and expanding. So I hope you that was helpful. And if you just read these fact patterns, do practice essays, compare your essay with the practice essay, and follow the pattern and highlight the important facts, you should do well. Thank you for listening. Take care. Have a great rest of your day. Bye.